topic I shared with you is the role of national court in foreign relations, and I hope that I can finish in time. Firstly, before my topic, I will introduce the theoretical premise. This doctrine is created by myself. I call it a three-stage theory for the emergence of international law. The three stages is that such as the norm emergency, norm cascade, and the norm internationalization. And norm emergency means that a state plays the role of a pioneer in the field of international law, taking the lead in adopting practices in a certain field that will produce corresponding legal significance and effects in international relations. Also, maybe there is some like rule maker that, as Professor Dodge mentioned in this morning. And normal cascade means that the other states influenced by that pioneer state have followed and adopted such practice, thus significantly expanding the impact of such practices, also called rule taker or rule followers, or practice followers. And norm internationalized means that as most states adopt those practices, there's a need and necessary to formalize them for better guiding interrelations and forms in forms of treaties and customs. And during these three stages, I think that state practice plays much important role during the development of international law. But when we mention the state practice, not every state practice, every kind of state conduct consists of practice. So state practice means that in international law, it means the conduct that contributes to the information or expression or rules of international and is attributable to a state. And according to the International Law Commission, the forms of state practice, including as such, diplomatic acts and correspondence, conduct in connection with treaties, executive conduct, legislative and administrative acts, and decisions of national courts, and so on. And among all these state practices, I think that reproducible practice are very, very important. Only this kind of practice can be sufficient, widespread, and followed, and effective, and provide effective for other states. And I think that all among these state practice, decisions of national courts have, among all these, the state practice, the decision of national courts, very important. For the advantage of the decision of national court as such that effective of res judicata, reproducible, consistent, and easily to be widespread. As we can find that the International Law Commission there's an important conclusion that contained in the draft conclusion on identification of customary international, as such that regard may be had as appropriate to decision of national courts concerning the existence and consent of rules of customary international as a subsidiary for the determination of such rules. And for decisions of national courts, if we viewed from the three-stage doctrine, we can find once a national court render decisions as a pioneer, such practice may be easily followed by other states. And once a judicial is made, it will have a lasting and stable legal effect and affect the expectations of social relations. And once the judicial process starts, it will follow the existing logic of judicial operation. And judicial relief has the prescribed path and so on. This is also the advantages and the functions for the decision of national law, especially from the three-stage doctrine. And another aspect for the functions of decision of electoral court, not from the three-stage doctrine, is that we can find that national court can interpret and apply international law from the perspective of national interests, through which participating in the creation of international law. And also, national court can not only fill in the gaps of international law, but also can make different voices in international law, so as to provide appreciate flexibility for its state foreign policy and provide possibilities for its practice at the international level. And for this, especially for the one voice, for the different voices, I will discuss the difference between one voice doctrine and two voice doctrines. So, from the perspective of one voice of two voices, we can find that from the perspective of different voices in variable international relations, although despite the existence of the one voice doctrine, I think this doctrine was followed by most of the common law system states, which emphasize that the domestic courts should be consistent with the administrations, especially in matters of foreign nations. So you should make consistent only to keep one voice with the, for example, for the Minister of Foreign Affairs. On the contrary, the distinction of voice, a large voice of a national court on certain issues, if the court provides a large voice, it really can provide flexibility for that state to act in international relations. Once such space is available, states have legal tools and to use it in the process of playing with other states. I call it a practice game. So we can find that on one hand, the one voice doctrine is not followed by every state. On the other hand, even for those states that put forward this doctrine, there's actually a lot of room for discuss on whether they really abide by it. I will show you an example. So now I will show you two cases. The case one is concerning the Italian domestic courts. For several years, Italian domestic courts have disregarded the jurisdiction immunity of Germany as a foreign state by allowing civil claims to be brought against Germany based on violation of international law committed by the German Reich during World War II. And we can find that in order to resolve this problem arising from Italian national courts practice, Germany is still proceeding against the Italian before the ICJ. And in the judgment delivered by the court in 2012, the court declared that the Italian Republic has violated the obligation to respect the immunity that Germany enjoyed under international law. But this is not the end of this story. Italian domestic courts since 2012 have entered a significant number of new claims against Germany that invalidate Germany's sovereign immunity. And in this judgment, especially in judgment 2014, rendered on October 2022, the Italian Constitutional Court acknowledged that the duty of the Italian judge to comply with the ruling of the ICJ judgment delivered in 2012 is very important. But on the other hand, the Constitutional Court substituted that same duty to the fundamental principle of judicial protection of fundamental rights under Italian constitutional law, which it read to permit individual claims by victims of war crimes and crimes against humanity to brought against some states. Since that judgment was rendered in 2014, at least 25 new cases have been brought against Germany. What's more, in at least 15 proceedings, Italian domestic courts have entered and decided upon claims against Germany in relation to conduct of the German Reich during World War II, and in many instances ordered Germany to pay compensation. So now, for this new practices, Germany decided to brought a new proceeding against Italy before the International Court of Justice, and this is a pending case. The second case happened in both the two states, in Singapore and in Canada, for the same accidents. We know that in 2000, a passenger airline operated by Singapore Airline, a company incorporated in Singapore, crashed while takeoff at an airport in Taiwan operated by the CAA. A number of passengers were killed or injured. And the injured passengers and the relatives of the deceased commenced proceeding in both two states. Now we can find that in Singapore and in Canada, we can find the difference. That the SIA maintains that the CA was wholly or partly responsible for the crash and sought to join it as a third party to proceedings, while CA claimed that it was a department under the Ministry of Transport and Communication of Taiwan and should enjoy immunity, state immunity. Upon suffice of the third party notice, the CA applied to set aside the notice on grounds that it was the Department of Taiwan and as such immunity from the jurisdiction of the Singapore court. But the Singapore court declined to uphold its allegation, its claims. So it failed. But in Canada, the CA claimed that the claim of CA is the same as it did before the Singapore court. But the court of the Canada holding that Taiwan possessed the conditions of statehood under customary international law, and it had to be treated as state under both international law and common law, and was entitled immunity from jurisdiction of the court in the present proceedings. The difference between these two states is that in the case before the Singapore courts, the Singapore court applies the one voice doctrine and declared that it should act consistent with the Foreign Ministry of Singapore. But before the Canada court, although Canada is the same, is the common law system, but it declined to apply the one voice doctrine. So why? So now goes to my conclusions or implications for the consideration of Chinese national court. On one hand, it's important for the courts to realize that they are the authors of international law. They have the right and obligation to interpret and apply the international law, taking into account Chinese legal interests during this process. On the other hand, in some cases, the court can also try to provide another voice that is different from the government to provide the practice game for Chinese government. Okay, this is my presentation. Thank you.